The CT12, that is for manufacturing, that is the pharmaceutical formulation, and the form number CT13, it is for getting permission in order to manufacture the active pharmaceutical ingredient, and both these are the unapproved one, right? Now these are the things that already we saw in our previous lecture. Now let us see the rule number 60, what it is and it deals with what. Rule number 60, it is associated with the grant of permission to manufacture the unapproved API for the development of pharmaceutical formulation for test or analysis or clinical trial or bioavailability and bioequivalence study. So rule 60, it is related with what? It is related with the grant of permission. Rule 59, it is associated with the application process. Rule 60, it is associated with the grant of permission in order to manufacture the unapproved API. So the clause under this rule 60, it will say that the central licensing agency may, after scrutiny of the information and documents furnished with the application under Rule 59, in Form CT12 and CT13, as the case may be, and such further inquiry, if any, as may be considered necessary. So CT12, it is for the pharmaceutical formulation, and CT13, it is for the active pharmaceutical ingredient. Note that all these are unapproved. So if central licensing agency is satisfied that the requirements of these rules have been complied with, grant of permission to the manufacturer of API in Form CT15 to manufacture the unapproved API and to manufacture the pharmaceutical formulation in Form CT14 for the development of pharmaceutical formulation for test or analysis or clinical trial or bioavailability and bioequivalence study within the 90 working days. So the application for unapproved API, that is in Form CT13, and the grant of permission, that is in Form CT14, right? For unapproved API, it is in Form CT15. Are you getting my point? So this is the form. This is the form, like say CT4, CT12. So this is the CT12 where it has gone. Okay, fine. For pharmaceutical formulation, the application that is to be made in CT12 form, and the approval will going to be received, grant of approval that will going to be received in Form CT14, right? Whereas in order to manufacture the API, the approval is going to be received in Form CT15, whereas the application that is to be made in Form CT13. Is it clear? For the unapproved API. So these are the different forms, and that process will be carried out within the 90 days period. Once the applicant apply in order to get approval to manufacture new drug or the investigational new drug for the process of clinical trial, BA study, test analysis, and the examination. If it is the case of unapproved API, in order to get approval of the unapproved API, the application that is to be made in the Form CT13, and for pharmaceutical formulation of unapproved API, the application that is to be made in the Form CT12. And to the same, the grant of permission that is going to be obtained in case of manufacturing of the unapproved API, it is the Form CT15, and it is the Form CT14 in case of the pharmaceutical formulation. Fine. And that whole process will require the 90 days. If not satisfied that the requirement of these rules have been complied with, reject the application, the reasons to be recorded in writing within a period of 90 working days from the date the application was made under sub rule 1 of rule 59 or so 90 working days, that is the time period, and within 90 working days the central licensing agency has to give reply to the applicant. If the CLA considers that there are some deficiencies in the application and the same may be rectified, the said authority shall inform the applicant of the deficiencies within the stipulated period referred to in clause 1. So, if any kind of deficiencies has been observed, if any kind of deficiencies has been found in case of an application of the applicant for the grant of permission to conduct the clinical trial, the same deficiencies will going to be communicated to the applicant and the applicant need to rectify all these deficiencies. Provided that in the case of rejection, the applicant may request CLA to reconsider the application within a period of 60 days. If the application is rejected by the central licensing agency, the applicant may request the central licensing agency to reconsider the same application, and that too should be carried out within 60 days from the date of rejection. The day on to which it has been rejected, from that day onward, within 60 days, the application request in order to reconsider is to be made on payment of fee as specified in the sixth schedule and submission of required information and documents. Next, an applicant who is aggrieved by the decision of CLA, Central Licensing Agency, under Sub-Rule 1 or Sub-Rule 2 may file an appeal before the central government within 60 days from the date of receipt of such rejection. If the applicant is rejected, the applicant may appeal to the central government within 60 days from the date of receipt of such rejection, and that the government may, after such inquiry and after giving an opportunity of being heard to the applicant, dispose of the application within a period of 60 days from the date of filing the appeal. The day on to which the applicant may file appeal, from that day onward within 60 days, the central government should carry out the inquiry, should hear to the applicant and dispose of the application or the dispose of the applicant's appeal, and for this the time period which is required, that is 60 days. Within 60 days of date of filing appeal, the process that to be carried out. Then there is a rule 61. Rule 61 that is associated with the validity period. Validity period of the permission to manufacture the unapproved API and its formulation for the test or analysis or say clinical trial or bioavailability and the bioequivalence studies. The permission granted under Rule 60 in Form CT14 or Form CT15, as the case may be, shall remain valid for a period of 3 years from the date of issue unless suspended or cancelled by the Central Licensing Agency. So the time period for which it will remain valid is the 3 years. Within 3 years, the clinical trial should be carried out, or the new for the new for the new drug or the investigational new drug for the purpose of examination, test, analysis, or the BABE study. In exceptional circumstances where Central Licensing Agency is satisfied about the necessity and exigencies, it may, on the request of applicant, write or made in writing by order and for reasons to be recorded, extend the period of permission granted for a further period of 1 year. So 3 year plus 1 year, and this 1 year that is in the exceptional circumstances. The rule 62 that is associated with the suspension or cancellation of permission to manufacture the unapproved API for development of formulation for test or analysis or clinical trial or BABE study. So this rule that is associated with the suspension or cancellation, what are the different conditions in which the application or the permission that may be suspended or cancelled? It is the suspension or cancellation of permission to manufacture the unapproved API. So, subject to provision of Rule 60, where the formulation manufacturer or an API manufacturer fails to comply with any provision of the Act and these rules, the Central Licensing Agency may, after giving an opportunity to show cause and after affording an opportunity of being heard by an order in writing, take one or more of the following actions. So the CLA that may go for either suspending or cancelling the permission. They may suspend the permission for such a period as considered appropriate. So based on the examination, based on the inquiry, the period which is found deemed to be fit, based on that or up to that period, the application that may be suspended or cancel the permission granted under Rule 60 in Form CT 14 or Form CT 15. Where the formulation manufacturer or API manufacturer whose permission has been suspended or cancelled under Sub Rule 1 is aggrieved by an order of Central Licensing Agency, such manufacturer may within 45 days of the receipt of the order make an appeal to the central government, and that government may, after such inquiry as deemed necessary and after affording an opportunity of being heard, pass such orders in relation thereto as case may considered appropriate in the facts and circumstances of the case. So it is the 45 days period within which the formulator or the manufacturer or the API manufacturer whose permission that is suspended or cancelled, he or she may go to appeal. Then there is a rule 63. So this rule 63, it relates with what? It relates with the different conditions of permission. So the permission granted under rule 60 in form CT 14 or form CT 15 shall be subject to the following conditions. So what are the different conditions in which the approval that is going to be granted? The manufacturer of pharmaceutical formulation and API referred to in clause 1 shall keep all necessary records to indicate the quantity of the drug that is to be procured. So particularly for the process of manufacturing, the quantity in which it need to be manufactured, the place where it is to be manufactured, all these are the different conditions, and it should be in accordance with that which has been specified into the application. And there is a need to go for maintaining the record of all the thing, the quantity of the drug that is procured, manufactured, used, disposed, all these. Where unapproved API and pharmaceutical formulation manufactured in accordance with the permission issued under Rule 60 is left over or remains unused or gets damaged, or its shelf life has expired or has been found to be of substandard quality, the same shall be destroyed and the action taken in respect thereof shall be recorded. So, if it has been found that the quality is not good, it is of substandard, it is of the spurious quality, then it should be destroyed and the actions need to be taken in respect thereof. Rule 64. Now this Rule 64 that is associated with the license to manufacture the unapproved API and for the development of formulation for the test or analysis or clinical trial or BABA study under the Drugs and Cosmetic Rules 1945. So Rule 64, it is related with what? It is related with the license to manufacture the unapproved API. Rule 62, 63 related with what? Rule 63, it is related with the different conditions of permission. So the clause under Rule 64, it will say that after obtaining permission under Rule 60, 60 that is the permission in order to manufacture the unapproved API or the unapproved API pharmaceutical formulation. After obtaining permission under Rule 60, the person intending to manufacture an approved API or pharmaceutical formulation of the new drug or IND for clinical trial or bioavailability or bioequivalence study or for examination, test and analysis shall make an application for grant of license to manufacture an approved API or pharmaceutical formulation for test or analysis or clinical trial or bioavailability in accordance with the provisions of the Act and the Drugs and Cosmetic Rules 1945. So it should be in accordance with that. The application referred in Sub-Rule 1 shall be accompanied by the permission granted under Rule 60 in Form CT 14 or Form CT 15, as the case may be obtained by the applicant from Central Licensing Agency to manufacture the unapproved API for the development of formulation for test or analysis or clinical trial or bioavailability and the bioequivalence studies. So they should have the CT14 and the CT15 forms. That is the rule number 64. That is the license associated with the manufacture of the unapproved API. Rule 65, it is related with the process of application. It is related with the process of inspection. Inspection of what? Inspection of the manufacture of unapproved API, active pharmaceutical ingredient, for the development of formulation. Now this formulation that is to be used for either test or analysis or clinical trial or BABA study or examination or analysis. So the inspection, that is the manufacturer of the API or formulation referred to in Rule 60, shall allow any officer authorized by Central Licensing Agency or the person authorized by the State Licensing Agency to enter the premises where the unapproved API is being manufactured. The Central Licensing Agency may appoint the inspectors, the State Licensing Agency may appoint the inspectors. Jointly they may come, alone they may come, and in that case, the manufacturer of the API or the formulation should allow the inspectors to enter the premises where the unapproved API or the unapproved API pharmaceutical formulation is being manufactured, stored, and used with or without prior notice to inspect the premises and records, inspect the manner in which the unapproved API is being manufactured or stored and used, and to take the samples thereof. The inspector may give notice or inspector may come without notice, and they can go for inspection of the premises, they can go for inspection of the records, they can go for inspecting the way by which, the manner by which the unapproved API is being manufactured, where it is being stored, and any of the record related with the unapproved API. They may also take these samples for the purpose of test. to the laboratories from the places, from the premises. Then rule number 66. So this rule 66 is associated with the labelings, the manner of labeling. So rule 66 says that what should be the labeling, how it should be, and it is in accordance with that of the rule number 66, the manner of the labeling. Any new drug or investigational new drug manufactured for the purpose of clinical trial or VII study shall be kept in containers being labels indicating the name of the drug or code number, batch, or lot number, wherever applicable, date of manufacture, use before date, storage conditions, name of the institution or organization, or the center where the clinical trial or BABE study is proposed to be conducted, the name, address of the manufacturer, and the purpose for which it has been manufactured. So all these are required in case of the labeling. Any new drug which is going to be manufactured, that should contain all these information onto the container. So that should contain the name of the drug, that should contain the code number, that should contain the batch, that should contain the lot number, the date of manufacture, use before date, that means it is the expiry date, the different storage conditions, the name of the institution or organization or the center where the city or the VAVA study is proposed to be conducted, the name and address of the manufacturer, and the purpose for which it has been manufactured. So all these informations are required, and all these informations need to be mentioned onto the product which is going to be manufactured for the process of either clinical trial or BABE or testing or analysis or examination. So that is the rule number 66. Where a new drug or an IND is manufactured by the permission holder on behalf of another person, the permission holder shall indicate on label of the container of such drug the name and address of the manufacturer and the person to whom it is being supplied, along with the scientific name of such drug if known, or the reference which shall enable such drug to be identified and the purpose for which it is manufactured. So let us say, for example, if the permission is taken by some another person, and on behalf of another person, if permission holder is going to be manufacturing, then they should contain all these information. No person or manufacturer shall alter, obliterate, or deface any inscription or mark made on the container, label, or wrapper of any new drug manufactured without permission of the Central Licensing Agency. So it should be in accordance with the rules, and any deviation to the rules, that is not at all permitted unless and until it is approved, unless and until it is permitted to do so by the Central Licensing Agency.